There we go. Good to go.
Thank you.
Well, is Judy on board yet? Judy Doche?
Not yet. She has not signed in yet.
Okay, so we're waiting for Judy. And Brad, is Amy Klein going to be here? Did I hear that?
I believe she was going to be here.
Okay, thank you.
And Judy's coming in right now, but we are live. And we do have a quorum, by the way, Madam Chair.
Thank you.
I mean, you could feel free to start whenever you'd like. I think I can stand in where necessary.
All right, welcome everyone to the June 8th Planning, Economic Development, and Land Use Committee meeting. Committee members present: Judy Doche, Alfredo Ballerin, Tom Hoey, and Joyce Love, and myself, Kathy Fahey, chair of the committee. Also our staff, John Raphael Bichard and Michelle Andre and Danielle Gillespie. From our planning staff, Director Brad Glass. Is that your correct title? I think
Yes.
so.
Yeah.
And Louis, I don't think I know you. Louis Roldan?
Yep, planner with the Department of Planning and
All right,
Development.
good to meet you, Louis.
Yep, nice to meet you.
All right, well, we're here to discuss two ordinances, Ordinance 84120 and Ordinance 158119. And we'll start with, Councilmember Doche's ordinance, 84120, an ordinance amending Chapter 375 of the Code of the City of Albany in relation to incentives for developers to use energy efficient and low impact designs. I'd like to start by seeing if there's anyone who wanted to give public comment on this specific ordinance.
First one we'll let in is Peter Sheehan.
Okay, welcome, Peter.
He's coming in right now.
Welcome, Pete. Hello, Pete. Pete?
He should be.
Hi, Pete. We understand you'd like to give comment on Judy Doche's ordinance, 84120.
Is he on mute?
He has two devices and.
All right, well, okay, unfortunately, Pete's not with us, probably technical difficulties here. So,
Hey, Kathy, can you hear me now?
hi, Pete.
Hey, how's it going?
Welcome, and you would like to comment on Judy Doche's ordinance 84120 that has to do with incentives for developers to use energy efficient and low impact designs. And please go ahead.
Okay.
If you could just
Yeah, so
name and address, please. And then go
say that again. Okay.
If you could just give your name and address and then go ahead
Sure.
with your comment.
Okay. My name is Peter Sheehan, and I live at 32 Buckingham Drive. And so in regards to ordinance number 8-41-20, you know, where low impact development measures, first off, I think these low impact development measures that they list in the, you know, that are part of the code now should actually just become part of the building code and have nothing to do with any of the trade-offs, you know, that are currently involved in it. And I mean, just so you know, the Sustainability Advisory Council, you know, is working on potentially adopting the stretch code. And with the, you know, Community Leadership and Climate Protection Act, the CLCPA, more efficient energy efficiency standards are going to be coming our way. So we should be doing this anyways. And so that's my first point. And my second point is that these trade-offs, I think, are just bad public policy in which the zoning regulations and what I would call the district fundamentals, the fundamentals of your residential district or whatever district you're in, what they are, the building heights, the setbacks, and everybody can plan for that and be prepared. And so those, and through this process end up being modified, and the zoning, the zoning districts basically end up getting infringed upon, which I think is bad public policy. And I would cite a couple of examples of 1121 Western Avenue and 563 New Scotland Avenue, where where the community didn't expect it because they knew what the regs were, they knew what the USDO was, and they certainly didn't expect these trade-offs, which resulted in higher density apartment complexes and more concentrated impacts, and that's not what was that's not what was expected. And of course, I think, but it bears repeating quickly that for 563 New Scotland and with 1121, but starting with 563 New Scotland, because it's closest to me, the community, when they found out that the proposed development, if it goes through, was going to be 5 stories instead of the regular 3 stories, in place, right there. And so once again, this ordinance, infringed upon, I think for lack of a better term, infringed upon the community's right to know what's being impacted. So that's why I think I think that ordinance, that needs to be changed. And so I'm glad to see I support Judy's ordinance here, obviously 84120. Okay, and now if I could, I just have some very brief comments on the other one, if I could.
Pete,
It's not time for that yet, right?
if you don't mind, we're going to hold off on that. We're going to discuss Judy's
Sure.
ordinance.
Okay. Thank you.
Okay, I'd also like to add that we have some other council members here. Mike O'Brien from the 12th Ward, Kelly Kimbrough from the 4th Ward, Ginny Farrell, Majority Leader from 13th Ward, and let's see, also Amy Klein from Council for the from Corporation Counsel's Office and for the Planning Department. And I think I've got it. And then our Council President, Corey Ellis. Okay, so we'll start with Judy. And
I'm sorry, Madam Chair.
Yes.
You have a comment from Peter and Wendy Gibson Constantakis, which talks about Councilmember Dochette's ordinance. Would you like me to?
I apologize. Please go ahead.
All right. Dear council members, as you well know, when someone mentions the word government, the standard response is often not positive. As people who work in government at the state level, we are not surprised by this, and in some cases, we unfortunately have to agree. One of the key things that leads to this negative public view is that the way decisions are made, and of course, some of the decisions themselves are often confounded to common sense. But I understand that this is often due to the lack of information. Communication is generally not a great trait of government, whether purposely or inadvertently, and it's easy to understand why the public gets confused and frustrated about the process. The good news is that it doesn't have to be this way. And with action to support, she talks about Councilmember Hoey's a little bit, but then she goes on to stress that she is in support of the green roof. I'll retain the rest of her comments because they tie in directly with Councilmember Hoey's ordinance that's also on the agenda for the evening.
All right, thank you very much. All right, so we'll continue now and we'll turn to Ms. Doche, and you can explain why you brought this legislation, amended legislation.
Thank you. First of all, I do want to respond to Mr. Sheehan's comment that I agree with, that really we should be we should be requiring green roofs of everybody whenever practical. And I had actually thought early on in the process in the discussion of the USDO when we were talking about sustainability that was something that could very well come out of the whole USDO process. So I don't want to dismiss that particular or have us overlook that particular comment as we look at this particular requirement. This particular ordinance, excuse me, I gotta turn down my phone. This particular ordinance would simply take what we did last year with regard to the suspension of the incentive for having a green roof and suspend it for another year. We passed that suspension fairly late last year, and it was expected at that time that we would be looking at two things. The establishment of clear standards to make sure that when we are giving people the incentive of either a greater setback or an additional story, to make sure that the green roof that is being established is actually meeting some significant environmental, we're reaping some significant environmental benefits from that. And without standards regarding how many inches of soil, how much of the roof needs to be green roof, etc., we're not really clear as to what are the trade-off benefits in exchange for the setback or the additional story. The other thing is at that particular point in time, we were not having any developers apply for the incentive for affordable housing. And as we all know, that's been a significant issue in the city of Albany. It's especially an issue when it comes to providing affordable housing in neighborhoods where there typically isn't, such as my particular neighborhood or the 8th Ward, etc., as opposed to having affordable housing be consolidated in some of the poorer and underserved neighborhoods exclusively. People should have the opportunity to live in a variety of neighborhoods without regard to being wealthy, essentially. Most of my constituents welcome a greater diversity of people and housing options in my neighborhood. So those two things were things that we were going to look at. How do we incentivize developers to utilize the affordable housing development incentive, and also looking at strengthening and developing actual standards for the green roof. We did not have an opportunity to do that around the time, last year Brad was working fast and furiously on massive changes to the USDO, and I did not want to bug him about this particular provision and the study that we needed to do during that time. And then around about the time that I realized that he may be freed up, we started dealing with the COVID crisis. So I think it's appropriate to continue the suspension for a year so that we do have an opportunity to fulfill the goals of studying those two particular issues.
Okay, thank you, Councilmember Darche. And my understanding is that the current ordinance expires on June 30th of this year, so the desire is to pass the ordinance before the current one expires. Is that correct?
The current ordinance provides for the suspension to end, not
Yes,
for
yes, the suspension. Brad, did you have any comments on this? I know the planning board has weighed in and they have made a decision on this, correct?
Yeah, not a lot of comment. I did just want to speak to some of Pete's comments. I think if you go back to the comprehensive plan, it spoke pretty clearly there about using incentives, and we did go forward to rewrite the code. The code was funded by NYSERDA, so obviously a lot of the incentives that came out of that were related to energy and the environment. As far as whether incentives are a good thing or a bad thing, I mean, that's a policy debate we can have another time, but I think that as far as Judy's ordinance is concerned, we support that. The planning board weighed in favorably. And, we appreciate, that other people are looking at the code and catching some things. I think this is something that we were beginning to realize as we evaluate these applications as well. But I thank the council member for pointing it out, as well as working with us to draft an ordinance that was, worked for both parties.
Can you update us at all about use of the affordable housing incentive? Has there been any takers on that?
No, I believe we looked and there were 7 projects that had used the incentive, one of the incentives. And I think 6 of those 7 at the time were either the green or the blue roof. We haven't seen anyone use the affordable housing incentive or the other incentive, which I believe is for a LEED certified building, since we have put this suspension into place. So I think it's something that we need to look at, whether we need to strengthen that or how we can, make a provision that works. Is my feeling is that the 20%, particularly with the deed restriction, may be too onerous for, incorporating that much affordable housing into a project. But it also depends, the incentive really depends upon the size of the building as well. I mean, if you're dealing with a really small footprint, you're really not getting that much out of the incentive. Whereas if you're dealing with a bigger footprint, you may be getting more out of that incentive. So I think that's one of the things we need to look at as we move forward too. Again, these are trade-offs too, and there's a question of whether the benefits in the project are being felt by the people in the immediate surrounding areas, or if it's more of a global benefit to the city. And that's a part of the debate that we should probably continue as well. Whether the immediate surrounding residents should be seeing the benefits of that additional story, or whether it's enough to say that that benefit is for the city as a whole, and therefore we should endorse it on that basis.
Okay, thank you. Other council members, anybody else would like to weigh in on this ordinance? Alfredo?
I'm just gonna be quick. It's the same issues I had with support of it. I supported for the same reasons as last year. I think we really need to increase. If we're gonna have incentives for additional affordability. I'm a big supporter of mixed income units. I am not a big supporter of just having affordable housing in certain sectors. That is a way of segregating our communities. And if you know or heard of, you saw the PPE report, it's something that we have unfortunately done in this city for too long. Mixed income projects allow for there to be a diversity of communities, but also for building to actually lift a community up versus when you have just concentration of poverty, you see disinvestment in certain communities. So I support this. I do hope we find creative ways to get developers to use the incentive. I wouldn't want to twinkle too much with that 20%, to be honest, because I think 20% is fair. I think if you get below 20%, now you really are having a situation where you don't have the impact that you want with these new developments. So I would want to be a little more cautious about going in that direction.
Okay, thank you, Councilmember Ballard. Anyone else want to weigh in before we put a motion on the floor? Councilmember Hoey.
Yeah, real brief. I'm in support of this. I supported it the last time it came up, and I think it's a good resolution. I'm sorry, good ordinance. Thank you, Judy.
Thank you. Do we have a motion on the floor?
I'll make a motion.
Okay.
Second.
A motion to
move 8.41.20 as amended forward with a positive recommendation.
and a second.
Second.
Any discussion? All right, all those in favor, please say aye.
Aye.
Okay, looks like it's unanimous. Thank you very much.
Thank you, everybody.
Okay, we will move forward now with Councilmember Hoey's ordinance 1581-19, and That's an ordinance amending Chapter 375 of the Code of the City of Albany by repealing subdivision 3, which is waivers of subsection B, procedure of section 375 5E14, which is the major development plan review, and requiring that any permit for the purposes of demolition or building be approved only if relevant prior approvals or conditions by city, county, state, or federal departments or agencies are met. So there's really two parts to this ordinance. And I think what we'll do is start with the waiver provision. And but before we do, I think I'd like to get our public comment, and I think it's important to hear what residents, the public, are saying about these provisions. And so if we could start with that, Danielle.
Okay, perfect. We do have some participants that want to provide their comments live that are in the waiting room. Pete Sheehan would like to speak to this ordinance, so I'm going to bring him back in.
All right, thank you.
Mr. Sheehan, you're back in, and we're on the topic of Mr. Hoey's ordinance.
Okay, thank you. Thank you. Wait, let me turn this off. Can you hear me?
Yes.
Oh, okay, good. Let me just get, yeah, so now, of course, we're talking about the next ordinance, which is number 15-81-19, of course. And the ordinance, I support Tom Hoey's ordinance, first off. And I've talked to a couple of people who live in Albany about this, you know, about the present situation. And so, and we, none of us agree that repealing the waivers and requiring that any permit for the purposes of demolition or building be approved only if all relevant prior approvals or conditions by the city, county, state, or federal departments or agencies are met. And in my opinion, this is basically a no-brainer. And, you know, this should just be, you know, just a basic component of Chapter 375, that if you're going to try to get a C of O for any, you know, for any development, any project, then all these conditions that Tom has listed in this ordinance should definitely be required. And I just, you know, all the relevant prior approvals, conditions by the city, and so on. And this definitely approves, I mean, this pertains to 1211, because I understand not all the conditions have been met yet, so they need to be met. And talking from the planning department, I know all the conditions yet haven't been met for 563, and I trust the planning department will follow through and make them, you know, make them comply with the, you know, with the conditions that they set forth to the project developers. So I'd like to see that. But in the meantime, I certainly support Tom Hoey's ordinance here, which would, you know, which would make these, make meeting these conditions a requirement. Okay, thank you.
Thank you very much. Next.
We have other members that have comments. JR will read the comments provided by Juliet Turner. I will share that these comments had to have been received by 12 noon. That was the deadline for submission.
Was that the only one in the waiting room, Danielle?
Yes, I don't see any other members in the waiting room.
All
Do you
right.
see
We have
anyone?
Vince Raguso who's in there, but yeah.
Okay.
Juliet Turner, 5 Tudor Road, Albany, New York, 12203. I live on Tudor Road in Albany and am writing to urge the Common Council to support the amendment to USDO Section 375 as proposed by Councilmember Tom Hoey to preserve and expand the parts of a city that attract residents and businesses who will contribute to strong and appropriate growth. A city needs to guide and control that growth through a system of procedures to be applied when new development is proposed. These procedures must, however, be open to amendment as conditions alter, or as in the case with the USDO, it is recognized that some corrections need to be made to ensure that the original goals of the document are realized. Needed changes to the USDO to clarify levels of authority and review have been discussed for years and will only become more necessary as so many aspects of city living are under changes. An immediate example would be the difference that the current pandemic will inevitably make in the way we live in our cities. The USDO should be flexible in making these adaptations, and the Common Council, representing the residents of the city, is the entity best suited to ensure that the terms of the ordinance keep current. Specifically, the present situation where the City of Albany Planning Board can override the USDO makes no logical sense. What does make logical sense is the proposed amendment that ensures that all conditions placed upon approval of a project must be met before a building permit is issued. That is not only logical, but also provides protection against potential danger. For example, the risk of working with high voltage power lines at the development at 1211 Western Avenue. The Common Council support of these amendments would benefit the city and its residents.
I believe we're going to let Mr. Raguso in now to share his comments.
It says he's connecting to audio. Must be, he has something on his end.
John Raphael, why don't we go ahead and read another?
I actually have his in writing too, so I can read it aloud. Planning, Economic Development, and Land Use, Honorable Kathy Fahey, Honorable Judy Doche, Honorable Alfredo Ballerin, Honorable Joyce Love, Honorable Tom Hoey. Vince Raguso is in favor of Thomas Hoey's amendment to the USDO. Only one of the primary purpose of this amendment to make mandatory for all conditions that are attached to any project in the City of Albany to be met before the project can move forward. It prevents the ability of the planning board to grant waivers, require the chief building official to enforce all relevant city, county, state, and federal requirements, and removes the ability of the chief planning official or chief building official from waiving or altering conditions placed by all relevant city, county, state, and federal entities. When the USDO was established and passed by the Common Council, there was a provision that after 6 months, the USDO would be revisited and tweaked. That never happened. The planning board had many excuses. Here we are almost 2 to 3 years and still nothing. Now, after many months passing, many more council members have their own problems with the USDO. So when do we tweak a 324-page document that was put together on the fly? Our representatives, the Common Council, that represents the residents of Albany, all 98,000 people, they, the council, are the ears and mouths of the residents, not the planning board. The planning board hears nothing. When we have a problem, we go to our ears and mouth, the council, and they should have the ability to hear our problems and make changes to fix any problems that needs fixing. The planning board currently has the ability to override the regulations and laws of the USDO. The planning board is an appointed body by the mayor, but the Common Council is an elected body of approximately 7,500 to 8,000 residents, and the Common Council representatives the taxpayers of Albany. Vince Raguso, 13 Beach Avenue, Albany, New York, 12203.
Thank you.
We have additional comments. We have a comment from Sue Swartz, who's also an Albany resident, 154 Holmesdale. I oppose Tom Hoey's proposed USDO amendment, as I believe this is merely an attempt to delay the construction on Western Ave, which I think should go forward ASAP. This needed development has been subjected to these delays in part because a small vocal group has been successful in having their way despite the presumed majority support of the construction. And then
we have
Chair.
Peter and Wendy Gibson Konstakis of 6 Tudor Road, Albany, New York. Dear council members, as you well know, when someone mentions the word government, the standard response is often not positive. As people who work in government at the state level We are not surprised by this, and in some cases, we unfortunately have to agree. One of the key things that leads to this negative public view is the way decisions are made. And of course, some of the decisions themselves are often confounding to common sense. But I understand that this is often due to lack of information. Communication is generally not a great trait of government, whether purposefully or inadvertently. And it is easy to understand why the public gets confused and frustrated about the process. The good news is that it doesn't have to be this way. And with action to support Councilman Hoey's proposed USDO amendment, you can help ensure the process is not only more transparent, which has rightly or wrongly in people's views has traditionally been to government at all levels, but also more sensible. We have tried to understand how a project could be allowed to move forward without first meeting all conditions for that project imposed by the planning board and other city requirements. Government action must be made in open process, not behind closed doors or in back rooms, regardless of their merits. It is the only way to ensure that the city retains authority over the project, and just as importantly, and possibly more importantly, to ensure accountability to the city, including its residents. While we certainly have opinions on certain projects in the city, in this case, that is moot here. Whether we support or oppose a project, it is vital that the project follows every condition imposed by the city. Yet, if there is no requirement that conditions be met before work begins, the city has conceded all its control and responsibility and potentially opened itself and community and residents to unintended consequences, some of which may have lasting effects. Again, we want to stress that the basic facts behind our views, which we see as vital to our city's future development. We can only imagine the city's response should a resident family decide that they do not need to adhere to planning board requirements. Clearly, that would not be allowed. So why has a planning board opposed to a USDO amendment that would ensure its requirements are met before a project begins? Do they believe they or someone in the city would be able to deal with errors after a project is underway? And what happens if the city finds the developer did not follow guidelines, especially in certain times like this? If you like an example, look at the history of the Uncle Sam Mall in Troy, where small businesses were forced to relocate for a major project. That project stopped halfway though, leaving the city with massive hole in the core of its downtown for years, as well as a well-deserved reputation of incompetence. We have always believed that Albany cares about its neighborhoods. When we lived in Center Square, Hudson Park years ago, we could not even paint our house without city approval. To allow a developer to begin a project with no legal assurance it will meet city conditions is an insult to all homeowners who meet city conditions. And sadly, the planning board apparently does not care. Optimism is usually a great trait, but it doesn't mean that you can or should abdicate responsibility. The planning board decisions must be upheld. If not, what is its purpose? We encourage the city council to take action to ensure that our city has a fair, transparent, responsible, and accountable process for the future of this city. And that requires the all development, commercial and residential, meet the basic standards set by the city. You have a chance now to do that. As government workers, we recognize the people often don't trust government. You have a chance to show the government is open, transparent, and responsive. Please do not let all that work that went into reviewing this process be jeopardized by not enforcing key protections. That's a risk we shouldn't and do not have to face. Make sure all developers meet the highest standards.
The next comment, Madam Chair, is from George Robinson, 10 Tryon Street. Following my previous submission, which was sent incomplete, regarding ordinance 158119, to Kathy Fahey, Chair of the Albany Common Council's Planning, Economic Development, and Land Use Committee. I support Councilmember Hoey's amendment to Chapter 375, which will limit the abusive waivers by the Albany Planning Board. Public health, safety, and rights to a democratic process are all challenged under the current system of decision-making, which places more emphasis on expedition than on greater public good. I have read the Planning Board's recommendation in response to the amendment and do not find it convincing. As a 27-year resident of the same Albany neighborhood, I am also not convinced that the Planning Board considers the best interest of Albany citizens in its decision-making. The elected members of the Common Council operate with greater transparency and have a better grasp of public needs, including our need to escape the social and economic costs of poor planning decisions. I urge your committee to approve this ordinance.
Any
The
others?
next-
We
the
have
next
several other
comment
comments.
is Elizabeth Berberian of 25 Clarendon Road, Albany, New York, 12203. My name is Elizabeth Berberian. I'm a 39-year resident of Albany. I moved to my current address in 2002. I love living in Albany because of its historical significance as the first chartered city in the United States, its historical significance and the built history which still remains for the natural beauty which surrounds the city, and performing arts available within the city in its immediate surroundings. I am grateful to live in the Eagle Hills neighborhood. I enjoy my neighbors and the friendly, caring atmosphere of my neighborhood. I take seriously my responsibility to be a good steward of my nearly 90-year-old house and its surrounding property, and I'm fulfilling my pledge to leave my homestead in better condition than when I purchased it. Living here has had its challenges and stressors. The last 8 years have been fraught with battles against encroaching development, and our comments have fallen upon deaf ears to an unresponsive planning board. I have been a frequent attendee of Albany Common Council meetings since 2012 and have attended several meetings of the Albany City Planning Board. I have noted that there is a strong depth of connection and respect between elected members of the City Council and the city residents. This is in sharp contrast to the minimal connection possessed by the appointed members of the insular and isolated Planning Board. I am here to support Tom Hoey's amendment to the USDO. I believe that now more than ever, the USDO must be a living document that can be easily updated at times and circumstances changes and when facts which support its revision are presented. We have become painfully aware of the extreme relevance and importance of this flexibility as we endure the pandemic and its unknown aftermath, which may have significant ramification on citizens' lifestyle choices. For example, the planning board supported by the city's leadership believes that high-rise, high-density buildings are the answer to the future housing needs of the city. Even before this pandemic, which will likely decrease the demand for dense living, Corey Ellis and I discussed how the need and the demand for buildings of this type and quantity had not been substantiated by the planning board. As members of the Common Council, your role is to represent the best interests of the residents of the city. Therefore, you must have the ability to adjust the USDO swiftly to meet residents' need. This ability should be yours and yours alone. The USDO was created in 2017 as the roadmap for development in the city of Albany. I have noted with great dismay that non-elected City of Albany Planning Board currently has the ability to override the regulations and laws of the USDO. My first request, therefore, is that the Common Council repeal Section 375-5E14, Roman numeral 3 of the USDO. This nonsensical last-minute addition to the USDO defeats and threatens the ordinance's very purpose of being. It allows the non-elected planning board to override the conditions of an ordinance created by a duly elected body, the Common Council, on behalf of the citizens of the city at will. In essence, a law was created which includes a clause allowing the planning board to nullify the very law at will. This provision has been used 3 times since 2017. I strongly hold that only an elected body such as the Common Council, whose members have their fingers in the pulse of the city and its residents, should have this right. Repealing this section would prevent the planning board from overriding the provisions in the USDO. Secondly, I am asking that the issuance of building or demolition permits within the city of Albany be prohibited unless all relevant prior approvals or conditions imposed by a city, county, state, or federal agency or department have been met. The requirements that all conditions set by staff of these agencies who are experts in their respective field must be met before a building permit is issued makes good common sense. However, it is also essential to ensure public health and safety. It provides safeguards against mistakes that could cost human life. This proposed building permit procedure process would provide a safeguard for human error and ensure that developers do not start construction or demolition without this assurance. Thank you for your support in the interests of the citizens of the city in these important matters. Lastly, I support also Councilwoman Judy Duche's moratorium extension of the green roof provision. That's that.
Madam Chair, we have 9 additional comments to be read for the record. May I proceed?
Well, How about we, I think, given that we've already spent quite a bit of time on public comment, maybe we should hold the rest till later in the meeting. So why don't we do that? So we're here, we've got, this ordinance has the two parts, and we'll start with a discussion of the waiver provision that pertains to the USDO, major development plan review. And just I want to read waivers. An applicant may request in writing a waiver or modification of any of the development plan review, development standards, and the planning board, this is current law, the planning board reserves the right to waive or otherwise modify such standards upon a finding that such action is necessary to eliminate practical difficulties associated with strict interpretation of these provisions, and that the result will not violate the spirit and intent of these provisions. Such requests shall set forth the specific relief sought and the reasons the same are necessary. So why don't we start, Tom, with you and discuss why you brought this part of the ordinance forth. And
Well,
then,
actually,
then we'll turn to planning department to have get their input as well.
thank you. I felt bad because my son Max had put in a comment. Today's his 13th birthday. I'm not supposed to say how old he is. And I missed they just did the cake with the candles, but this is more important right now. Okay, so this waiver was actually came after the second part. I had discussions with council members on the second part of this ordinance I'm working on. And then they pointed out that there is a waiver in there that allows the planning board to override anything that's in the USDO. I think that goes against the purpose of the USDO. I did not vote on the USDO in 2017. I took office in January of 2018. I think it's just, in my mind, common sense that you don't allow somebody to be above the law. And that's what we're allowing with this waiver in there, that the planning board can override something that's written down as law. And I've argued this, that it's the legislative body, the common council, that passes ordinances, not the planning board, not the planning department, but the common council itself, the legislative body of the city of Albany. And pretty much, I mean, it's common sense to me. Why would you give somebody the right to override a written law? Now, I've gone to the meetings, I've heard the arguments back and forth. Well, you know, it's going to slow the process down. If there's a problem with the USDO where you have to offer a waiver, why don't we just change the USDO and fix it? It just doesn't make sense to allow waivers, to allow an unelected body, to allow them to have that power to do it. And they make mistakes. We all make mistakes. We're human. There's 15 of us, 5 of them. So I think there's a lot less chance of the council making a mistake rather than an appointed body. So I think I'll leave it at that, and I might want to jump back later. Thank you.
All right, thank you, Tom. So I'm going to turn now to the planning department. Brad, I don't know if you or Amy, I just want to point out, I hope that committee members did have a chance to read through a pretty extensive recommendation by the planning board, taking a look at this provision about waivers. So Brad, if you could step in and have a discussion that.
Can I jump in here?
Judy, I really want you to wait until the planning department. Please hold on, okay?
But you.
Brad, I'd like the planning department to discuss their position on this ordinance. If you could unmute Brad, please.
Can you hear me now?
Yep.
Okay. So I'm going to go through some of the things that were articulated in the planning board's decision. Foremost concern with
Hold it. I'm sorry. This gets to the basic of my question that I need to ask before we talk about this document and the planning board's decision. So my question is, was this entire document, because I watched the video as Kathy requested, was this entire 11-page document put before the planning board as their decision? They didn't vote on this decision. This is the opinion of the administration that was not specifically voted on by the planning board.
All right.
I would like to know when this was drafted.
All right.
When it was presented to the planning board, before we start talking about this as the planning board decision.
We drafted the decision as we do all the decisions, and that decision was endorsed as representative of the meeting and the planning board's thoughts by the chair of the planning board.
So this is like taking a resolution and saying basically, okay, we're going to authorize somebody else to draft the resolution after we take some sort of general kind of vote before the council, as opposed to the council having a resolution with the actual language in front of them when they vote. This is, I've never seen this in my 30 years of working for the Department of Health, with advising various councils and boards, too numerous to mention. They always had the exact language that they were being asked to vote on in front of them. And we've had a situation like this maybe 6 months ago, where we were provided with a different ordinance than what was presented to the planning board when it came to cell towers. We're still waiting for that. So I respect that this is the decision and the opinion of the administration, but to present this entire document as though it was before the planning board and the planning board is in agreement with everything being said in this particular document is misleading.
Okay, thank you, Judy. Brad, do you want to respond?
That's the way that we've done the board drafting of all the decisions for the 13 years since I've worked for the city. So I understand now that that's apparently not the common way of doing it, but that's the way that we've instructed our staff to do it. And that's the way that, I was always trained to do it as long as I've been here. So I was not of the opinion that there's anything, and never been advised by council that there was anything wrong with that means of doing things. So if you'd like me to speak for myself or for the department, I'm happy to do that.
Okay, please do. Brad, go ahead.
Okay, so with respect to the ordinance, there are two things. I think there's some terminology and some wording that we felt was poorly worded, or things that weren't put in the proper place in the ordinance, and I will get to that. That's one of the reasons we do ask that these things are shared, and it's a process between the parties working going forward, because sometimes we can point out that whether or not we disagree with the content, we might know where it's most apt to be placed within the ordinance. With respect to the waivers, the goal, as was stated by Councilmember Hoey's ordinance, was to reduce ambiguities, among others. So if a waiver doesn't go to the planning board, the Board of Zoning Appeals has the power to grant an area variance. And really, this is there's standards by state law that are applied, and it's for practical difficulties related to developing your land. The Board of Zoning Appeals already has the power through an area variance to waive the provisions of the USDO. They are subject to articulated standards, which is slightly different than the waiver provision in our code. And that's one area where we do agree with the councilman, is that we could substitute those same standards into the planning board process. So there are coherent standards that they're applying. But really what this allows the planning board to do, and this was, as was researched by our council in general city law, the reason that the legislature, as far as we could find, allowed the planning board to adopt these waiver provisions are, related to streamlining the process. So you don't necessarily have to go to two boards, and that's not just for us and for the board members, but that's for the members of the public too. If the planning board already has an application before it for development, that may require varying some standards, rather than also sending that application to the Board of Zoning Appeals, the planning board could potentially waive those standards. And just to give you some background, this same provision verbatim was included in the 1993 zoning code. It's been law in the city since 1993 until the current date, and it's been used sparingly. That said, we still believe there's a logical public policy reason to have the waiver provision in there. Again, you know, there may be some provisions of the code, the base dimensional requirements, heights, parking regulations that we don't expect the planning board really to ever be waiving. Those are things that should go to the Board of Zoning Appeals. And we clearly work to distinguish those from other elements. But there are landscaping provisions, there are lighting provisions, there are qualitative standards. You know, the zoning board is usually looking at quantitative standards. So, you know, something, you know, you're proposing a 20-foot setback when a 25-foot is required. When it says, you know, this lighting needs to cast light on a building in a certain way, a yes or no question from a variance is not always the way to go. The planning board, you know, may have the ability to vary that in the case of their review to create a, you know, the same circumstance may not work for each building. And one of the things we did with the USDO is we took a lot of unwritten rules and we codified them. So in my feeling, and I understand that not everyone feels this way, but I feel that it is a very transparent document. We had maybe 4 pages of development standards related to the Pine Bush and one other area of the city in the prior zoning code. There are over 40 pages now, I believe, of development standards that apply to each development: lighting, landscaping, access and circulation, building and streetscape design, many of which were never articulated in codified form. That means the planning board literally on a whim, each time it got a project, may have applied them differently. That's not the case anymore. That said, there are certain provisions such as, for example, a curb cut is a maximum of 20 feet width in the USDO. That's the allowance. Actually, our traffic division prefers 24 feet as a base standard. So, I mean, would it be reasonable for an applicant in that case to ask for a waiver to allow a 24-foot curb cut rather than a 20-foot curb cut? And would that really be warranting of a completely separate hearing before the Board of Zoning Appeals for that matter, and maybe any number of other matters within those 40 pages of document, you know, that might need to be tweaked a little bit. I mean, the planning board does have to have some authority to conduct its role. Otherwise, you know, to some degree, we might want to just make these as of right projects. Because, you know, I mean, again, they're applying the standards and, you know, they have a function or role to make discretionary decisions where appropriate. I think I'm going to leave it at that for the waiver provision. But I did want to get into, and actually when I first read the ordinance, this was of a little bit even greater concern to me, was some of the wording with respect to building permits, because I just don't think it's practical for a building inspector. You know, and I checked and there were 3,300 building permits that were issued last year.
Are we talking about the same thing now, Kathy? I mean, he's jumping into the second part.
Oh, sorry, did we want
And we're gonna hold off. We're just gonna focus on the waiver section right now. So we'll hold off. Can you hold off your comments until?
Yeah, I don't know if it, you know, I guess I would just say, if Amy, if you wanted to add anything, I think you did some of the research with respect to the state law that, you know, endorsed planning boards, you know, adopting these sorts of provisions and what the purpose behind that was.
Sure. So I would just mention at first that this was circulated to all of the planning board members, but I will speak for myself, you know, from the legal perspective on this. I looked through the bill jacket for this law, as well as the bill jacket for a law that was passed the year earlier for towns and villages that essentially did the same thing. There was not a lot of legislative history in terms of this specific waiver provision. But from what I can tell, it was really, you know, it was intended for, it wasn't intended to allow the planning board to grant a waiver from anything in the USDO. That's clear. It was intended to allow waivers from a limited set of site plan and special permit procedures which would be separated out into a different section of the ordinance, especially at that time around the, you know, the late 80s and the early 90s. So, you know, to the extent that things like, you know, height limits and area restrictions are included in the general development standards in the USDO and the general district standards, sorry, the waiver provision wouldn't apply. So it wouldn't just allow the planning board to, grant any waiver from anything. Councilmember Hoey mentioned that he thought that this was, taking over the city council's legislative function. And I would just mention on that, and that, this argument has been made in various places across the country. Some states have found that provisions like this are, they go too far, but New York has not. New York's courts have upheld the waiver provision. The Court of Appeals has done so. They've applied it in various circumstances. So while I understand that argument, and I think, it makes a certain amount of sense, it's just not what the law is in New York.
Just real quickly, Brad, going back to you, can you explain to committee members the couple ways, there's only a couple ways the waiver actually has been used in the last few years?
Yeah, I'm trying to channel. There was a request, I believe, for exception or an allowance to provide parking off-site, I believe, which was rejected. And there was a request to modify the allowable size of parking spaces in a parking lot that was being reconfigured to be 8.5 by 18 feet as opposed to 9 by 18 feet. Again, I think the latter example is a good example of the fact that having something that minor to go to the Board of Zoning Appeals for an area variance is exorbitant use of everyone's time.
It's time, but it's also costly. Is that correct? And that was a major criticism of development projects prior to instituting the USDO.
Yeah, and I just want to communicate to the council, area variances in general are down significantly from when we passed the other code. So by and large, people are conforming to the code that's in place. We used to have an average of over 100 variances a year cases. Lately, we've been having 15, 20, maybe max. So it's significant administrative benefit to allow us to focus on other things like neighborhood planning or even more effectively scrutinizing the planning board applications that are before us.
I just want to emphasize too that this really, it would really just shift the ambiguity in the process over to the variance side of things, as opposed to removing it. So to the extent that the goal is to reduce the ambiguity of the USDO, I think that there are ways that could be done. Certainly by really looking at which provisions of the development standards, should be allowed to have this kind of waiver versus, are there certain things that should be set aside as, not being subject to the waiver provision.
Okay.
And just to underscore is, we're not looking to solely dismiss the point that the council member is making. I think there are ways to improve the provision to have more clearly articulated standards that the board can assess and the public can feel comfortable that they're weighing in the context of these applications. But just to remove it entirely, to me, doesn't make sense.
Tom, did you want to respond to that? Actually look at tailoring it a little bit? So that
at this point, I could throw back the thing, let's put it in, and if we find there's problems, we can always adjust the USDO, and hopefully it would be better. It's going to be a year in July that this ordinance came up. So maybe we can work out a way we can get changes to the USDO done in a much timelier fashion, like, maybe a couple of months. So my feeling is let's move forward, and if we do run into problems, let's adjust it. I'm always open to change, but to leave this like this and there's been a lot of foot dragging with this ordinance, and I need to move forward with it.
Okay, I'm going to open it up to other members of the committee. Judy? Councilmember Doche.
Thank you. So with regard to a couple comments here. The idea of taking, first of all, I want to say, on the one hand, there's some commentary here that all of a sudden we're going to have so many more variances going to the BZA because we're not allowing waivers. On the other hand, we've identified 3 in 3 years since the adoption where the waiver provision has been used. That's number one. So I don't see this creating a huge influx of work for the BZA. With regard to the parking lot analysis that was provided, I do wonder why we don't look at changing the provisions in the USDO. What's good for the goose is good for the gander with regard to why did we make a waiver exception for that particular person, and is it possible to incorporate standards that would allow that kind of flexibility for other developers, and why not put that in the USDO? I'm just responding to that as one particular example. Brad also mentioned curb cuts and the length of a curb cut. Kathy, you and I, have had conversations about the mobile station and the length of the curb cut there, creating problem for pedestrians and safety issues. The beauty of referring something to the BZA is there's a clearly established standard for an area variance, and there's a clearly established process where the public can then comment on it, and then there's a clearly established process where we understand what the appeal process is from that. When you delegate the ability to waive a provision, I'm really not sure where the public gets to weigh in and what that appeal process is. So I think that this makes a lot of sense. We have a process. We've only had 3 cases in which maybe it would have gone to the BZA. Why not have those go to the BZA? I also want to remind you of in our training with NICOM, there was discussion about how some municipalities combine the planning board with the BZA, and you expressed an interest in that, Kathy, with the design and the historic resources kind of review being combined in a different board, and that might help a different kind of streamlining of here's the body that is looking at compliance with the technical provisions and also potential variances and the variance process, and another body that is looking a little bit more at some of the design issues that a lot of the public has expressed a lot of interest in. With regard with regard to the statement regarding the ambiguity shift to the BZA, I don't really agree with that because they do have those kind of clear standards. We're talking about potentially, the administration is suggesting that maybe you take those standards that apply to the BZA and now you duplicate that process in the planning board process, and I don't understand why we would do that rather than just follow the process. And the final thing I want to talk about is while our state courts have recognized that this is not an unlawful delegation of legislative authority to allow this kind of waiver, Amy has properly pointed out that other states have. Regardless of what our courts have said, the courts certainly have not said, and it's inappropriate for you to say, for any individual municipality to say, no, we're not going to delegate that kind of responsibility to a legislative body. So those are my comments on this. Thank you.
Okay, any other committee members want to weigh in on this? Any other council members? Okay, I'll give my 2 cents on this. I do agree with.
I'm sorry, Chairwoman. Michael O'Brien raised his hand.
All right, very good. Thank you. Go ahead, Mike.
Oh. Well, a couple of things. I agree with Tom Hoey. I think it's a sensible argument that the waivers seem to have not been something that we really contemplated. It seems to me at all sensible that the council basically intended to leave that authority for itself. I very much agree with what Judy said on several points. I think Judy correctly pointed out that this decision, this multi-page decision, as far as we know, was never formally ratified by the planning board and probably reflects far more than they absolutely discussed in their public meeting. This was a similar problem to what we had with the zoning board back in February, when they had a very loose discussion about the blood plasma, and then that got spun up into a multi-page decision, which they never reconvened to ratify. So I think you have the same problem here, whether this really is the thinking of the planning board or just the thinking of the administration. And I agree with Judy's point too, that there is nothing in New York State law that says it's improper for the council to want to limit some of this delegation of authority. And I don't know, to me, it's become a lot more pervasive maybe than we actually think. I mean, I'll give you one example, which I've had just very, very recently on 60 Coven Avenue. The planning department approved an application as complete. At the same time that 60 Coven Avenue appears on our 2030 plan as a potential brownfield, and that application doesn't say one damn word about it being a brownfield. So to me, it seems like kind of a tacit waiver of a really significant thing of, are they going to pay heed to how brownfields are supposed to be mitigated, or are they just going to let a developer submit whatever he wants, saying that the ground is clean, and not even acknowledge that the city's master planning document identified it as a, and so that seems to me that this whole waiver practice is kind of getting rampant. And I think it's a very sensible, I think Tom's purpose and the simplicity of the amendment seems to me to make exquisite sense. And that's all I have to say.
Okay, thank you, Mike. Okay, well, the whole issue of this not being ratified by the planning board, I think is something that we can continue to discuss. But as far as the ideas put forth here about some of the problems with the ordinance, I tend to agree with. I'm concerned that that you do make things more complicated. There are some situations that can be remedied easily without having to go to the Board of Zoning Appeals. It just lengthens the whole process, makes it difficult for our staff, but also it impacts how developers feel about doing business in the City of Albany. We want to see development here in the City of Albany. We're all going to benefit from that. As far as our budget, increased revenue, increased quality of life, I think, when you have development proposals and projects. And I like to think that we should be able to give our our planning board that ability to make those decisions when needed. It's the whole idea of reducing red tape. And I'm concerned that we've had an offer by our planning department to take a look at this process, the waiver process, and tighten it up. And I think I'd like to see Councilmember Hoey sit down with the planning department and maybe there's situations where we shouldn't be using a waiver and some we should. That should be reflected in the ordinance.
Councilwoman Fahey, we have Councilmember Duche and Councilmember Ballerin who have their hand up.
Okay, very good. So In fact, I know Brad has put forth suggested amendments, and I wondered too, Councilmember Hoey, if you have considered those amendments and why we can't do that beforehand rather than later.
I think we should pass this ordinance and then we'll work with them on it. This is the way.
It's like going backwards, though.
Well, Kathy, you put this USDO in 2017. We were supposed to do a 6-month review. How many years has it been for the 6-month review? Let's put the onus on them to come back with us with the changes they need. But we need to get rid of this waiver.
Okay, and then there are other comments?
Yes, Madam Chair, would you like me to read the other comments that were submitted, or did you want to?
No, I'm sorry.
Okay.
Did you have something to say? I saw your hand.
You're talking to me?
Yeah.
All right. So one of the things I want to make sure that we're all aware of is that the USDO does have some section where the Chief Planning Officer has extensive authority to waive very specific requirements to a modest amount, so maybe reducing the setback requirement by 5% or something. I forget what the whole list is, but I believe that there's like 15 or 20 things in the USDO where we have spelled out modifications in order to eliminate some of the red tape. We discussed that with the USDO when the USDO was passed, and we agreed to those. And so maybe there are some other specific items that staff wants to put forward rather than having this be some sort of blanket approval. If you look at the memo that was drafted up for us, there's a list of about 8 things that where waivers in other municipalities have been used for things that we would otherwise think would be appropriate for a variance, and have been used for a variance, whether it's fencing requirements or setbacks or parking requirements, etc. So this is currently far too extensive. I also want to say that it is my belief that the administration is also granting waivers outside of this particular requirement or this particular provision without providing the full justification by novel interpretations of the USDO that are not supported by the language in the USDO. So part of the problem here is having a faith that the waiver requirements as written are going to be narrowly construed. Finally, with regard to the idea of further discussions, etc., with regard to this particular provision, this has been around for over 10 months. It was introduced over 9 months ago. And there's been ample opportunity for the administration to engage and submit to us alternative language, submit their own ordinance that would correct this kind of issue. And so I think that they've had ample opportunity, especially when we look at what happened 3 years ago, where we were given over a 300-page document and expected to essentially rubber stamp it. We worked fast and furiously at getting additional community input into things that were of concern when we finally saw the actual language that they were proposing for adoption. And we adopted that within 3 months. So for us to now grant the administration on this small little ordinance some extension of time, I just don't see the necessity. We've had 3 waivers in 3 years, and there is an opportunity to amend the USDO to address, to learn from those, and to amend the USDO to specifically address them and make sure there's community input into these kinds of changes. Thank you.
Brad, go ahead.
I just wanted to submit, we did have an alternate version of the ordinance that we provided to Tom as a
In
suggested
January, yeah.
alternative. So we tried a couple different versions. It does get difficult. Again, we're talking about 40 or some odd pages to identify each one that can be applied for a waiver and each one that cannot be applied for a waiver. After trying it several different ways, we concluded upon taking away the ability to grant waivers for dimensional standards, parking regulations, and signs. I believe were the three that we felt should be solely the jurisdiction of the Board of Zoning Appeals. It was the other sections like landscaping, lighting, those sorts of things that we felt were more after the planning board approval. Judy spoke to Councilwoman Doshate spoke to the administrative adjustments that the chief planning official can grant for small amounts related to, those are very principally related to dimensional standards. There may be a handful of others that are not dimensional standards, but again, dimensional standards is one of those 8 chapters dedicated to development standards within the code. So those other 7 chapters, there's no provision given to the chief planning official to waive any of those.
All right, thank you. I think that unless anybody else has any input, I'm going to put it to the committee. It does sound like there is support for this ordinance. So if somebody would like to issue.
I would like, I'm sorry, I guess as being someone that's been on the other side, I guess I'd like to give the opportunity to hear all the comments. The people who took the time to write in. I know there's quite a few.
Oh, yeah, okay.
Before we voted, you know, I think that's.
I agree. Danielle, we'll have to read the other comments now.
I got a fast question before she starts. Are we going to do the second part of the ordinance? Are we voting on each part or the whole ordinance?
Oh, that's a very good question, Tom. I guess we will have to move into discussion before we vote. Thank you. Danielle, go ahead.
Yes, Madam Chair. This next comment is from Lawrence Whitner. As a resident of the City of Albany for more than 4 decades, I'm writing to urge support by the Common Council's Planning Committee of the amendments to the Unified Sustainable Development Ordinance proposed by Common Council member Tom Hoey. In my opinion, these amendments are sensible, for they clarify what is expected of landowners, developers, and residents, thus removing the ambiguities introduced by the Planning Board's ability to provide a waiver from USDO standards on the basis of vague practical difficulties. Hoey's amendments would require that all conditions for project approval be fulfilled before the project begins, and this too strikes me as perfectly reasonable, particularly in light of the controversial development taking place at 1211 Western Avenue. The next comments are brief from Daniel and Madeline Kennedy. We support Tom Hoey's proposed legislation regarding changes to the USDO.
The next one is from Nancy Harrigan. I want to let you know of my interest and support for the council's approval of the proposed amendment to the Albany's Unified Sustainable Development Ordinance regarding waivers of development standards by the Albany Planning Board. The current permission for the board to grant waivers is too broad and undefined. The development standards now spelled out in the USDO are in danger of being ignored or eroded by unlimited waivers and thereby defeating a major purpose of the USDO. Furthermore, the always important public trust in fair and even-handed application of the USDO is on shaky grounds when no measures are in place to guide or circumscribe waiver grants and no oversight is available to the Common Council or other body to assure proper and lawful compliance. I am frequently reminded of the enormous and unchecked power of the APB when I recall during discussions of 1211 Western Avenue. The clear expressions by department personnel that comments from the public and council members carry no weight or influence for the board. That attitude should not be allowed to drive execution of the USDO. It seems the Common Council has given up a lot of authority when it adopted the USDO, but I think it's unwise and wrong that it, and therefore the public and residents, be shut out and up in favor of limitless power in an administrative panel. I hope these comments will be helpful to you and others considering next steps. Please feel free to share as you think advisable.
The next comment is from Stephen Burke of 11 Clarendon Road, which reads, "The voices of residents have been ignored or dismissed without due consideration since at least 2013. City planning board officials and the city administration officials are employed by the residents to represent them, not developers or outside investors. The APB has and continues to conduct development activities and has conducted its planning duties to the detriment of established residential neighborhoods. Outside developers are favored over city residents. The APB has overridden basic criteria and essential conditions made by various city departments without justification or sound planning/economic rationales under the current USDO 375-5E provision. It is imperative that the Common Council find in favor of this amendment to assure the USDO is implemented per its intent, to foster the restoration of the residents' serious loss of trust in the integrity of the planning process in the city. Rebuttal of APB's unfavorable recommendation dated April 21st of 2020. A major development plan review. Applicant may request waiver of review of any standards. Why have standards that can be arbitrarily dismissed? Hence, why have a planning board? Planning board seeks to reserve the current ability to waive or modify any standards to eliminate practical difficulties. All proposals must address all codes, standards, and other provisions of the USDO, NYS, federal and international codes. Proper design and engineering of project-specific challenges is fundamental to the design process. It should be necessary for the city agencies to issue allowances to enable developers to correct design deficiencies by circumventing USDO standards and criteria. Section 1, items 1, 3, 4, and 5. Project proposal issues that are considered by developers to be burdensome or that present practical difficulties are simply the result of design defects or aspects, design standards of the USDO they dislike. Maintaining the current waiver language defeats the intent of having a zoning development ordinance at its most fundamental level. The provision as it currently exists and employed allows unlimited discretion by the APB. It allows continued violations of the spirit of the code and overrides sound technical objectives voiced in public input. In addition, and the subject of future action, the amendment should be expanded to prevent any such practical difficulties from being simply converted and waived under a variance relief action. The suggestion that variance or relief would be the APB's course is a clear indication that the spirit of planning and acceptance of public input is a subject of no interest to the APB's review process. Experience reflects that the APB relies on numerous variations to authorize inappropriate developments. This is not a matter of a single issue, but rather of allowing a one-stop review to bypass numerous major variations, resulting in the approval of highly controversial and inappropriate developments. The reliance on carryover provision from the city's previous zoning ordinance is not relevant. The USDO is by design intended to be a living document. Its core provisions must be implemented. This amendment seeks to correct a clear and primary abuse of authority in the planning stages and approval substandard, dangerous, and irresponsible developments. Issues contained in the APB recommendations at sections 2 and 3 are not relevant to this core objection to retain waiver authority in the USDO leading to proposal, approval, disapproval action. Summary. The APB seeks support in the waiver of ambiguities. Argument as justification for retaining the provisions in the USDO. Do not be misled. The waivers characteristically granted by the APB concern basic, fundamental, and critical review criteria and have solid technical, architectural, engineering, economic, and social implications. There is clearly nothing ambiguous related to applicable standards for high-density apartments, sanitary and stormwater flows, state and federal water quality issues, fire codes, public safety, density violations, etc. Please vote in support of this amendment to the USDO in furtherance of correction of the issue of concern presented in item 1. There's also a comment provided by Nancy Creeman of 8 Clarendon Road in the City of Albany. Good evening. My name is Nancy Creeman. I live at 8 Clarendon Road, Albany. I have lived here for the last 5 years. I enjoy my quiet neighborhood, yet in close proximity to the heart of the city. In the time I've lived here, I've dealt with numerous traffic tie-ups during rush hour, 2 that have resulted in 2 to 3 car pileups on Western Avenue. I can only imagine this continuing should the project at 1211 Western be given the final green light. That being said, please consider the following in preventing this unwanted, unnecessary, and not well thought out project to be given the go-ahead. The USDO should be a living document and updated as times change, a particularly relevant issue under our present existence during the pandemic. The Common Council represents the residents of this city and should have the ability to adjust the USDO more swiftly to meet residents' needs. The City of Albany Planning Board currently has the ability to override the regulations and laws of the USDO, which defeats the purpose of presenting a plan that is fair and transparent for all those affected. It is a requirement that all conditions set by governmental agencies who are experts in their respective fields must be met before a building permit is issued. This is just common sense and provides safeguards against a mistake that could cost human life. High tension power lines on Western Ave are an example of the potential for a dangerous error at 1211. I stand in support of Councilwoman Judy Dochette's moratorium extension of the green roof provision. Next comment is from Katina Mavadnes. My name is Katina Mavadnes and I live at 59 Melrose Avenue. I am speaking to you in support of Ordinance 158119. As I have mentioned on previous occasions, there needs to be legislative oversight of an unelected municipal body. This ordinance provides this necessary provision and restores the necessary system of checks and balances as required by law. In addition, the Common Council represents the citizens' needs, and the USDO has to be ultimately responsive to the citizens' concerns. Unfortunately, as of late, the stakeholders' interests in this city have been sadly overlooked. Again, this ordinance furnishes the required correction to this continuing problem. Finally, in the planning process, unintended errors can occur. There has to be a way to catch these problems before they cause significant liability and safety issues. This ordinance gives the protection, which is important since these errors, if not caught, could cost the city dearly. The next comment is from Max Hoey of the City of Albany. My name is Max Hoey and today is my 13th birthday, and I know my dad will be late for my party because of this legislation you are hearing about tonight. My dad is very concerned about the USDO that the city passed many years ago, and he feels that my safety and the safety of my friends are in danger because it needs to be updated. I'm planning on studying to be an architect as I like to build things. My dad has friends who are architects and engineers and have heard the discussions that they have had about certain standards that are based on cost savings and not on safety. When I see the buildings that Albany has put up over the past 300 years, I marvel at their uniqueness and solid construction. I am born and bred in Albany, and this is my town as well as my friends. What you do today will impact us for the next century. Let us not lose sight that this is Albany and is not New York City. And in light of the virus that is hitting the world, density is dangerous today. I appreciate you letting me share my opinion and hope you understand and support my dad. Thank you, Max Hoey. Thank you.
I'll read the next one. This one is from Picket Companies. Nancy E. Carey Cassidy, Executive Vice President and Chief Operating Officer. Dear President Ellis, I write on behalf of the Picket Companies to express our strong support for proposed ordinance number 1581.19, sponsored by Councilmember Thomas Hoey to amend Section 375 of the Unified Sustainable Development Ordinance, USDO of the City of Albany. We understand that the proposed amendment would repeal 375 E14 Roman numeral 3, which would presently authorizes the planning board to waive or modify development plan review development standards under certain circumstances, and B, prohibits the issuance of a building permit or demolition permit unless all relevant prior approvals or conditions imposed by a city, county, state, or federal agency or department have first been met. The picket companies believe that the proposed amendments serve to both promote consistency in the application of the USDO as written and to protect the public health, safety, and welfare by ensuring that all government requirements and conditions are met before building or demolition can begin. For this reason, the picket company respectfully urges the Common Council to adopt proposed ordinance 15.81.19. The address is 20 Corporate Woods Boulevard, Albany, New York, 12211. And then the last one that I have here is from Amy Lolick of 23 Tudor Road, Albany, New York, 12203. I am writing today in support of amendments to the USDO 375 proposed by Councilman Tom Hoey. Please enter these comments on record and share them to council members during the June 8th council meeting. According to the city's website, Albany's USDO is quoted, a modernized zoning ordinance, which incentivizes the interests of our community with protecting our natural environment. My understanding of the ordinance as it was presented upon its inception as a living document has hardly proved to be the case. After attending numerous common council meetings in anticipation of any proposed amendments to the USDO, I remain increasingly frustrated. The intent that the language of the USDO would not remain static is further reflected in the statement on the city's website. It is necessary to periodically review and revise the USDO in order to provide the best suited regulations for new and changing conditions as they arise. Without revisionability, your constituents' contribution to the ordinance remains anemic and frail. The proposed amendment are perfectly aligned with the intent of the USDO safeguarding community interests and natural environmental concerns while simultaneously avoiding subjective interpretation of local, state, and federal regulations. Therefore, I am urging the council to support the amendment to the USDO Section 375.
Okay, thank you, JR. So this second part of the ordinance would amend the Unified Development Ordinance of the City of Albany to ensure that no building permit or demolition permit is issued prior to any condition precedent set by a city, county, state, or federal agency or department is met. Okay, Tom, do you want to tell
Sure.
us a little bit about why you brought this forth, please?
Yeah, and this one really made the other one come out too. First, I want to talk about Peacock is one of the major developers in our area. They own Corporate Woods and many buildings in the City of Albany, major developer, and their lawyers looked at my ordinance and you saw the letter. I want to talk about 1211, and that's come up a lot, and a lot of the people who've commented tonight are being impacted by 1211. They were opposed to the development, and in fact, the mayor was opposed to it when originally it was going to be a dorm. It's still going to be a dorm. Let's not kid ourselves, but they're calling it luxury apartments. We went to the planning board many times, and we did a lot of the work for the developer there, where there was defects, and that they got corrected because we brought them up. One of the departments was the fire department. This development is going to have close to 270, close to 300 people in the building. There's only one way in and out, and that's on Western Avenue. And there's no way to fight a fire there. The only way you can fight it is from Western Avenue. So that in itself had me worried. The fire department looked at it and said, yes, you may proceed with this development, but the utility lines, which some of them are 16,000 volt high tension electricity, must be buried before the project begins. That letter went to the planning board, went to Brad Glass, went to Chris Spencer, and the planning board's decision was, you can tear down the building, you can put up the new building, but we're not going to give you a CO until the lines are buried. Now, I'm concerned about the workers who work on this building. These buildings have a tendency, because they're totally made out of wood, and I sent the members of the committee pictures of what happens. There's been over 30 of these fires with these buildings while they're being constructed. The only way to fight that fire is from Western Avenue. Do we want to put our fire department in danger with a metal ladder going up, trying to fight a fire with that high tension electric? Now, that is why I crafted this ordinance with, by the way, I want to mention that this was crafted by Jared first, and then Jared left and it was a bit of a break, and then JR looked at it. So I've had two people on, council attorneys looking at this, and they felt that this is a good ordinance to go forward. So I wanted to get that out there. Now, I did meet with Brad, I met with Chris, and they said, well, it was a mistake that was made. We told the planning board the wrong thing. Do you really think we would allow them to put up a building with those lines not buried? And I thought, oh, okay, good. Send me the changes. Well, it took them almost 3 months to get me the changes. But in the meantime, I heard that Chris Spencer was down at National Grid arguing with the developer that they should just get the letter so they can start the work. And in fact, Rick LaJoy was ready to issue a permit to start the work on this site without the lines being buried, without the letter from National Grid. I called the mayor's office. That's been put on hold. That project stopped. So I want to see this go in. I mean, this is a mistake. I don't know what happened, but the planning board overrode what a city agency said was going to be safe. And, and Mike O'Brien, who had to leave, he had a similar problem with, they want to put up a building on a brownfield and it slipped through the cracks. This is like a circuit breaker. It will prevent, if something comes up, it will prevent danger, something that's dangerous or not shouldn't go through. Now, at the planning board meeting, I kept hearing, well, this is putting more regulation, more law. All we're saying is that if a condition is there, let's get it fixed before we issue a permit. It's not extra work for Rick LaJoy. The planning board should tell him we have these conditions, or, and he waits to make sure that he gets the conditions fixed before he issues a permit. This is mom and apple pie in my mind, okay? And I'm very passionate about it because I don't want to go through my life, if this building goes up and somebody gets killed because we did not look at it. We're more worried about getting tax revenue. We're more worried about putting up buildings that, it's for the money. Come on, let's be honest. I don't want that on my conscience, that I didn't fight to the end to get this in there, to save people's lives. And this is for every ward. This isn't just my project up here at 1211. And I'm not against the building. If they bury those lines and get them in there like they're supposed to, what can I do? That's the decision. That's the law. That's what's supposed to happen. But to totally ignore what the fire department said, and I sent it to the members on this committee. You got the fire department's letter. You got the lawyer's letter who appealed to Chris Spencer right after the decision that you need to fix this. He never heard back from Chris. Okay, so this is what I'm dealing with, and I am passionate, I'm emotional, but I think it's common sense. And I hope the members on this committee will support me on this. Thank you.
Okay, thank you, Tom. Now,
just for the record, Councilman Conti is in here now.
oh, yes, and I see Councilmember Farrell and Councilmember Conti. I think we've got everybody else. Okay, so, I totally understand your concerns about public safety, absolutely. So our staff, in conjunction with the planning board, has written a recommendation here on this part of the ordinance and brought up a lot of concerns about the ordinance. So I'm going to ask Brad and anyone else, Amy, or anyone else who wants to discuss it to begin to tackle this a little bit and explain your concerns about this part of the ordinance.
I mean, I think a lot of it comes down to the wording of it, in a sense. There are some, for instance, with respect to demolition permits, it seeks to amend Section 375E17C, which is the review criteria for demolition review. It's a separate process. The language relevant to demolition permits is in Chapter 133 of the code. So that's really the section that should be amended. And I'd also add that the review criteria, if this were to be put under demolition review, it's selective, it's not prohibitive. You don't need to meet all the review criteria. In that case, it essentially lays out the things that the planning board can consider as weighted in making its decision. There already are a number of sections in the ordinance that speak to or say essentially the same thing. I guess I understand a little bit more now Tom's motivation for this. Our concern is putting and it's a very practical concern because, we get, gotcha stuff all the time. We get, accused of doing things that are honestly sometimes totally, innocently, overlooked or something. But, you're putting the onus on a building inspector essentially before he gets a building permit to make sure that every state, local, federal, county, et cetera, approval has been met. Some of which practically can't even take place until, after the case. So you're opening a restaurant, for instance, you need to get a building permit, but you can't get your state health inspection permit until, that restaurant is up and running. So it can't practically occur. And then the way it's written, it leaves the building or the inspector to determine the relevancy of whether that federal or state law is relevant to the circumstance or not. I just think it needs to be more explicit in what it's asking the reviewer to do. And again, I think there are other examples in the code. I've laid out, or the planning board has laid out 5 in the recommendation that speak to or say very similar things in a more articulate manner and in a more effective manner, I think. So frankly, I think it's unnecessary, and I think it just muddies the waters for everyone involved.
Okay, thank you.
I want to respond to that. Fred, you were at that meeting and you looked me in the eye and told me you were not going to allow them to move forward with that building till those lines are buried. So now you're totally saying that didn't happen.
I will not stamp those plans or any plans until all conditions have been met. I have ethics. That's always been my point of view, and that always will be my point of view.
So will you let that building go up if they just get a letter saying that they could bury the lines? The fire department specifically said no work was to start till those lines are buried. And that's what this is about, Brad, and you know it. And you said to my face,
I want the plan for the burial of the lines to be a stamped part of that plan set document that is issued for the project.
But that's not what the fire department requested. So you're changing what an agency of the city said. You're changing it, right?
That's more concrete than the fire department requested. That's
No,
saying we're not even stamping that. You need stamp plans to get a building permit, a demolition permit, or anything. They don't have stamp plans. Yes, I understand the building department did take their permit set to review their building plans in advance of any of this, but they did not issue anything as far as I'm aware.
Yeah, because the mayor's office stopped it because I raised hell. Okay,
Well,
Brad?
Tom, I will stop it as well.
Well, it didn't happen. I'm sorry. And those lines cannot be buried. I'm telling you now. But we'll leave it at that. I mean, but why didn't you address the planning board that night and say, guys, you got this wrong? I mean, you didn't. And then you got a letter from an attorney and you totally ignored it. I mean, I'll leave it at that.
I'm concerned that, the discussion on this specific incident shouldn't really be such a big part of our discussion on this ordinance, because this is going to apply to projects throughout the city.
And the brownfield on Calvin Avenue that was overlooked. So this does happen. And all I want is a safety check. And this doesn't mean they got to go out. This is if something's brought to their attention, it's due diligence is what we're looking for.
And I think that's, that makes a lot of sense. But I guess when I read through, and I'll just say what I think, when I read through this, these recommendations, this here from the planning department, they're saying that a lot of what you're asking for is already in the USDO. So I'm concerned about that kind of redundancy here.
Well, I'd rather be redundant and for safety, to save somebody's life, to save a fire department's life, to save people living in that apartment house's lives. Let's get stuff done right, okay? This is what it's about. That's why I was elected, to represent the people in my area, and they're worried. You've heard it tonight. There was 15, 16. One person was against it. I am for it. This building can go up. I'm not trying to slow it down. I just want the law followed, and it's not
Okay.
being placed right now.
All right, thank you. And let's turn to other committee members who might have comments. Anyone have comments? Judy? Please unmute Judy.
Thank you. Sometimes it takes a couple times for my iPad to respond. Well, I'm supportive of this. I'm a little confused as to why there is such opposition if essentially people are saying it is already addressed in the code. Some of the opposition, I read with interest this 1975 Court of Appeals case. It's a 45-year-old case that appears to be talking about an old statute. Having worked for the Department of Health, there was never any issue with regard to the approval of various nursing homes and hospitals. Very important public policy that you do not want scarce healthcare dollars being expended on the building of a building that is intended to be used for a nursing home or a hospital if it's not going to be approved for that particular purpose. And we have that agency, and again, this is one of the boards or councils that I was an advisor to. We always put decisions before them. Tom Young, who you're familiar with, Kathy, was in charge of the architectural department that actually reviewed in details the plans for hospitals and nursing homes to make sure that they would be in compliance with the state code as well as the building code, frankly, to make sure that it was being done economically because we have Medicaid dollars behind it, et cetera. So it's very important for something like that to have the prior approval of the State Hospital Planning and Review Council in terms of what is going to be built and where it's going to be built and who it's going to serve. And in general, I am concerned. There is a provision in this also that precludes the chief planning officer from waiving these provisions. So this is not only about having the planning board being able to waive provisions, but also potentially the chief planning officer to make it clear that he does not have the ability to waive or modify provisions that where there is a clear requirement for some sort of permit or other department approval. One of the places where we've had issues in the City of Albany is lack of requiring compliance with the ADA. And we certainly, early on in my tenure, heard from a lot of people who were concerned about a couple of things that were put up without there being any compliance for accessibility for disabled individuals. And that indeed was unfortunate. So people need to be cognizant of the fact that various developments, various projects are gonna touch on other issues. And if we're not requiring as is suggested here, every single building inspector to be cognizant of every single requirement, what we are requiring is that globally the planning department be aware of when something may require approval from the Department of Health, something may require approval from the Department of Environmental Conservation, making sure that there's compliance with ADA kinds of requirements generally, and then have the appropriate agencies chime in and review those plans and make sure that the plans are acceptable to the agencies, as Bill Ritchie puts it, to the people who are the experts in those particular areas. And I agree with Bill Ritchie in his comment that this is just common sense. And it should not be something that is, you know, subject of such debate, as far as I'm concerned. So thank you. That concludes my comments.
Councilman Ballerin, and then Councilwoman, I actually want to add something into after Councilman O'Ballerin.
I'm sorry, Councilmember Ballerin.
Okay. Oh, can you guys hear me? Okay.
Yes.
So I just want to touch on two things. One, when it comes to the waiver, I think the process that we went through to get the rezone, whenever there's a complaint about certain aspects of rezone, it always falls back to the process of how we went about it. That there was meetings, there was multiple meetings, and there was an opportunity for people to have their input at those meetings before it went before the council in 2017. Now we can have a discussion about whether that process was reached everybody that should have or not, but that's not the discussion we're having today. The fact that there's a waiver after all of that creates even more frustration with residents that have concerns about what's occurring, because if this is a document that we all agreed on, or actually I wasn't on the council back in 2017, but if this is what was agreed upon in 2017, then, you know, now what are these waivers that were not agreed on? So I understand the frustrations from residents, and I understand the frustration from council members. As far as the safety issues, I think we should be making sure that all these buildings are safe as possible before we move them forward. You know, there's a lot of issues that can occur throughout constructions in these projects. I know I've had several, two that have gotten started in my ward. One that has I've gotten lots of phone calls regarding vibrations and other issues that come up with these buildings when it's being constructed. I think it is good and sound measures to make sure that we are crossing our T's and dotting our I's before, you know, we have anything break ground. It's just for the safety of everyone involved, as well as the residents that live in those areas. Thank you.
Thanks, Alfredo. John Raphael, did you have something?
Yeah, I just want to touch on real quick on the relevant prior approvals. I know Brad had made mention that this is probably imposing on them to start looking at like county health stuff. And it's really not. It's, for example, with a restaurant, when it comes to the county health, that's after a building permit has been issued, because the way the law is written, it says all relevant prior approvals. I mean, just from what I've learned with a lot of the USDO amendments is that some of this stuff has to get approval from county planning board if it's within 500 feet of a state highway or state property. There's a lot of relevant prior approvals that need to be done anyway. And this just, the point of this from what talks with Councilman Hoey on this is just the relevant prior approvals. I don't see how a county health for a restaurant that we need, that it needs prior approval, that requires after it's been built. I mean, we're not trying to overburden the planning and buildings department with things. It's just putting it in code that this needs to be followed. And in just watching planning board meetings, I see plenty of times, all the time, that they make referrals to, for example, the water department or another entity prior to any approvals being done when it comes to a building. So I don't see how this makes it any more burdensome than when it's already done.
Okay, Brad, do you want to respond to that at all?
Well, I'm just, you know, it would be helpful to have a list of the approvals that we're talking about. I mean, I don't, you know,
I think, Brad,
if we could better see
when you
what approvals we're
if-
being asked to administer, we could better, make the assessment of how difficult that's going to be.
I would agree with that. And I would say that, insofar as you guys keep talking about relevant prior approvals, if you know what those relevant prior approvals are, I think that, it would make more sense to specify those as opposed to, making it out of the whole entire universe of, regulations that may apply.
Yeah, I merely suggested an example because of other examples that were being made that were far less concerning of things, related to health and the environment that why would we not want to enforce them? That was how it was posed. So I responded with a practical example of something that may pose a conflict for a staff member.
Okay, thank you. Other comments? Okay, well, one of the concerns that was raised that some of this is already in the USDO. It's already required to have the approval, license, or permit in effect at the time that an application is submitted for a permit or approval, and at all times when the use is operating. Failure to do so is a violation of the USDO. It's already in the USDO, so why are we repeating that is one question. And the fact that the chief planning official or chief building officer already has the authority and duty to issue permits for proposed projects that are found to comply with all applicable ordinances and codes, and to inspect approved projects during construction and upon completion to ensure compliance with the USDO and other applicable ordinance and codes. This is already in the USDO. Why? So why are we, Tom, I don't know, maybe it didn't happen, did happen. I'm not sure about this particular situation you're talking about, but I'm concerned with, are we going to be approving something that's could be redundant?
Well, if it is, we can always change it, Kathy, and let's get this process
Well, why?
going.
Why, Tom? If it's
I err on the safety. I err on the side of safety, and I'd rather be more conservative with this than liberal and progressive where we lose lives. And if you can, I'm going to leave it at that.
Okay, and I know, Amy, do you want to comment on this, some of the other issues that were brought up in the planning board decision?
I mean, I did a bit of legal research, and I think, part of the issue is that there may be these situations where there are other relevant approvals, but it becomes this kind of catch-22 because that approval requires local approval first, and if local approval is requiring, the other approval first, then how is anybody supposed to actually get the permit issued? So that's an issue. I also think, there's perhaps a problem where if the building inspector was given authority to essentially, deny a permit based on, the possible ultimate denial of some other agency, you then have the building inspector enforcing some other law or regulation, which may not even be local in nature. You could have the building inspector basically applying like EPA rules or something like that. And that would, go beyond what the building inspector really has authority to do. I think, again, as Brad said, with the waiver provision, we're not saying that we object to, your intent here. And I think that we want to work with the council to try and come up with some type of language that makes sense where, the issue that you're trying to address is a little bit better tailored to, what the ordinance is going to say.
Tom, are you open to taking another look at this and
I can't. This is important right now, and I'm ready to move forward and ask the council to move forward.
Judy, do you have comments?
Yeah, I'm having some difficulty with the administration picking apart in detail this ordinance in the way that they're doing, when I would have liked the opportunity to have this kind of dialogue regarding a lot of the USDO and the 300 plus pages. And also we're still waiting for our 6-month review, and we know that there are a lot of problems with the existing USDO. So I think that there's a double standard here, and I think that it is designed to defeat Mr. Howie's ordinance for whatever reason, even though what we're hearing is, it's kind of talk about catch-22, it's internally inconsistent argument. This is already covered, but we're opposed to it. With regard to the comments about they would like us to list in detail what prior approvals we're referring to, I do want to comment that some of the USDO provisions that they are citing refers to without first obtaining all appropriate development permits and approvals and complying with the terms and conditions. So why is that not listed? Why not list out everything that they put in the USDO? Again, a double standard is at play that I think that is just sort of a filibuster with regard to Mr. Howie's ordinance. And finally, I want to say that with regard to the argument that there's catch-22, in terms of you may have a situation in which you need the local approval before you need the other approval, and back and forth like that. That is usually something that reasonable minds can figure out if there is something where that arises. But again, since we're being asked to list what prior approvals we're talking about, I would like this, I want to say, speculative comment to be backed up with a specific example where that will arise before we spend any more time trying to address these comments. The provisions are reasonable, they're common sense, and I don't really see why we should be wordsmithing this to death when we have other provisions of the USDO that really should have been corrected a long time ago with regard to citations, wording, ambiguities, internal inconsistencies, etc. Thank you.
Brad, you had your hand up, and Amy.
Yeah, I just, the idea that this is the administration doing some, having some goal or objective. These are the staff, these are the people that administer laws on a daily basis, pointing out concerns with a piece of legislation and the way that it's written. And I just feel like it's falling on deaf ears. It's very frustrating, but all I'm asking is we take a step back and we make it, and I don't want there to be a perception that I'm asking people to wait or whatever. That's fine. We'll put in, if you want to pass this, we'll put in a separate ordinance that is a preferred version of the ordinance, and you can debate that. But I just feel like, we're rushing this through for I don't understand. It's a poorly worded ordinance, in my opinion. And, I just think it could be better. It could accomplish something, but it's not really accomplishing, it's just related to, I'm going to leave it at that. Thank you. Thank you for having us at the meeting.
Amy?
I was just going to say that liquor licenses are one area where you need the local approval before you can get a state approval. Just to give you an example, but I would also agree with Brad's comments.
Okay, thanks. Any other comments?
Councilman Ballard.
I understand the frustrations with the planning department. I hope you understand that we have a lot of that same frustration as well, especially for new council members that have nothing to do with the UFB. We never got an opportunity to vote on it or or wordsmith it at all. So we only have this new 300+ page document that we have had a lot of frustration with, that we have very little say in, especially with our residents of asking for some changes in some of these developments. We have no say. We come to your planning board and we beg for small changes, and we are not heard. So if you feel some frustration, we have had this frustration for over 2.5 years. And, you know, this has been on the plate for 10 months. I understand my colleagues' frustration with this. I understand your frustration. But at this point, I would say, let's this be a starting point of us trying to improve our relationships. Let's move this forward for Councilman Hoey. And then if the planning board wants to come with a revised version, then let's look at that revised version. Let's give it a timely, speedy manner. Let's look at other council members' concerns they have with the UFB. Let's bring the whole document to us from the planning board. I am a little frustrated with reading something in one article that somebody was quoted as if they were holding that because they were afraid the Common Council would change more. And I'm not sure if that was from the planning department or elsewhere, but that shouldn't be the case. It shouldn't be the case. So I understand your frustration. I hope you understand our frustration. And I hope this is a catechist to get us to start working in a better relationship. But I'm for moving this forward, and I'm for listening to your revised proposals in a different bill.
All right.
My son's birthday is right now. I gotta go. I'd like to move this. Can I move this with I'd like to move this
motion on the table.
with a favorable recommendation. Can I get somebody second me, please? Joyce is seconding it.
Second by Joyce Love.
Okay, discussion. I'll begin the discussion. I'm disappointed with this committee. I think that you have a planning department with professionals. You have a planning board with people who have backgrounds that give them the ability to evaluate our planning needs here in the city of Albany. And I feel like, honestly, that they haven't been respected. And I understand that the council does have final authority on a lot of these decisions, and they should, but I don't think it should be taken, what I think is cavalierly. When you have professionals that are making suggestions to you on complicated issues, I think that they deserve a great deal of consideration. And I don't see that happening here. And I have to say, I'm really disappointed. So those are my comments. Anybody else want to make comments? All right, let's take a vote. All in favor?
Aye.
Aye.
Okay, and
Aye.
I will vote against. So 4-1, and the ordinance does move forward to the full council with a positive recommendation.
Thank you.
Thank you, everyone, for your time tonight. Thank you, staff. Thank you, council members. I really appreciate your time. Motion to adjourn.
I make a motion to adjourn.
Second.
Okay, good night, everyone.
Enjoy the birthday,
Good night,
Tom.
everybody.